morning, Counsel.
Good morning, Your Honor. May it please the Court, my name is Michael Schneider, and I represent the defendant appellant in this case, Margaret Earle. This morning I hope to address the first two issues in my brief, the sufficiency issue and the statute of limitations issue. With respect to the first issue, the sufficiency issue, it is the defendant's position that the evidence in this case was sufficient to support a manslaughter verdict, but it was absolutely not sufficient as a matter of law to support a second-degree murder verdict. There was absolutely no evidence, contrary to the Commonwealth's contention, that Ms. Earle witnessed Burnham fatally assault her daughter, nor is there any evidence that she had any knowledge that he had done so.
Well, isn't there quite a long litany of injuries and bruises and behavior that suggested this child was suffering from serious injuries?
Well, first 2 points. The Commonwealth's primary contention that Earle had actually witnessed the assault is based on its contention that Ms. Earle went upstairs, had some drinks, she was drinking fast and heavy according to Ms. Snow, and that she was not in a festive mood, even though this was her 21st birthday, the following day. That is not a sufficient basis from which to infer that Ms. Earle had actually witnessed Michael Burnham stomp this girl's abdomen. With respect to the Commonwealth's effort to dump a lot of prior bad act evidence onto the record, I think this Court has to be careful, even under the Lattimore standard, in parsing the history of so-called abuse and so-called prior bad acts very carefully. Remember, there were 9 Commonwealth witnesses who testified that Ms. Earle was a loving and caring mother who took her daughter to play dates.
Okay, what about when she dropped the baby down the stairs? And what about when she dropped the baby from the top of the crib?
There was evidence from a narrow band of witnesses that the Commonwealth put forth.
It's evidence.
Yes, that's correct, Your Honor. That is correct. Okay. But there was also.
But how can one say that it's a loving mother who throws her baby down the stairs and then calls for her husband to go pick the baby up? And how can one say that it's a loving mother who drops the baby from the top of the crib into the bottom?
There is no question that Walter Pelletier and some of the Pelletier family members and the Burnham family members gave a testimony that was very unkind to Ms. Earle and that suggested that there was something that was abusive.
The question is whether this evidence that she puts the child in danger of death or serious injury, is that a sufficient premise for murder? And my question is whether these acts by her are sufficient. Because, I mean, taking your view that there wasn't, assuming that there wasn't sufficient evidence that she knew that night what he had done, then do her other acts mean that she puts the child in danger of death or serious injury?
Absolutely not. I mean, there was undisputed, even under Lattimore. Well, I understand that you can look at what Pelletier testified to, what the Burnham family members testified to, and you can certainly draw some inferences from that. Even under Lattimore, the court is obligated to look at undisputed evidence, and there was undisputed evidence that Ms. Earle, unlike a lot of these other manslaughter cases like Gallison and Michaud and so forth, there's undisputed evidence that Ms. Earle took her daughter to the pediatrician's office repeatedly for well child visits and immunization visits, that she attended to her medical needs otherwise. Even the pathologist testified that the girl was well nourished at the time of death. And so
she hadn't gained any weight in 3 or 4 months.
Well, the testimony was, in fact, that she had, in the last 5 months, despite having upper GI and intestinal problems, and despite the fact that she had some kind of problems that resulted in throwing up, she was actually maintaining her weight, and by the time of her death, she had actually increased her weight by a pound.
I believe there was evidence that it's abnormal for a child not to gain weight over several months.
But there was absolutely far more evidence than not that the girl was a proper weight, or an appropriate weight for her age. There absolutely was evidence on the record. But even if
it's relative, she hadn't gained weight over several months.
There was a 5-month period. Ms. Earle took her daughter to the pediatrician's office February, approximately 1 month before the incident. And the pediatrician diagnosed her as having upper GI problems. She had been vomiting. I mean, the girl had some sort of upper GI problems. There's undisputed evidence of that. So even George Loro, the pathologist who conducted the autopsy, said that the girl was well nourished, and that given the GI problems, her weight was not a problem. It was not indicative of failure to thrive. There were a couple of pieces of outlying evidence from one of the nurses that maybe there was some suggestion of failure to thrive, but that was completely rejected by the doctors that actually conducted the autopsy.
Isn't it somewhat irrelevant whether or not she was a good mother or a bad mother, or how good or how bad? The real issue is whether, in light of the child's condition, the time in question, a reasonable person would have known that there was a plain and strong likelihood the child would die if immediate medical attention wasn't.
Well, that's exactly right, Justice Cordy. I would agree with that completely. I do think that it's fair to look at the history of the mother in relationship to the child. The court has repeatedly said that. But the real issue was on Thursday morning, given that there was insufficient evidence that there was no evidence that she had actually witnessed Burnham do anything. Did she know that that there was a plain and substantial likelihood that death would result from not doing anything that morning? And I think if you look carefully, and you have to parse and look closely at the testimony of all three of the physicians, I think it was clear that that a mother in her position wouldn't have known. Dr. Loro says specifically that a lay person, even after the onset of full-blown peritonitis, and that's a very important distinction as to when exactly the symptoms associated with that occurred that morning. Even Dr. Loro testified repeatedly, both on direct in response to the Commonwealth's questions and on cross in response to the defense lawyer's questions, that a lay person would know that the girl was seriously ill but not dying. And
what evidence is there of phone calls to the doctor that would have made a difference in this case? I was a little confused by the back and forth. What evidence of phone calls that morning, the morning of the death?
So there was evidence that Ms. Earle did not testify at the trial. So the only testimony that we get 2 decades later, because this case was tried essentially 2 decades later, was statements that she made to one of the investigating officers in the week after the incident. So she had told the officer that she had made a call early in the morning. I think the officer says, in one case she says 9:30 or 10, in another case she says 11, and that she was told that the child probably had the flu, that she should give the child fluids and monitor the child, and that the officer would be coming into the Hanover office, the other office, the doctor, would be coming into the Hanover office at noon, and she should call back then. What there was on the record, the only phone records that were actually introduced into evidence, was evidence of a 4-minute call at noon at the Hanover office. The Commonwealth tried to argue that, well, she was simply covering her tracks at that point, and that she really had no intention of seeking any medical advice. But I would suggest that that's a very far-fetched inference from that.
Wasn't it the babysitter who wound up calling the police?
The babysitter ended up calling the police. Ms. Earle went down to the pharmacy to get some things, including something for her daughter. And while she was downstairs, she left the baby with the babysitters. That's the other thing that's very important to
13-year-old babysitter.
Yes, she did leave them with...
A baby who's this sick.
Well, but let's also remember that Ms. Earle was 19. She was 17 when she got pregnant, and she was 18 when she had the child. I would suggest that the evidence was really more consonant with a very young woman who was extremely immature and had no idea how serious this is. And when you look carefully at the
Well, the 13-year-old called the police.
The 13-year-old called the police when the baby called her mother when the baby stopped breathing. If you actually look at what the child's behavior was, I think you'll see that up until the time that at some point she starts to become lethargic, and undoubtedly Ms. Earle does not pick up that something has happened at that point. There's no evidence that she saw the child's abdomen or saw the swelling or the hardening of the belly, although one of the docs says that without training and without the ability to actually open the child up and look, you wouldn't have known that this was peritonitis. It takes training. You wouldn't have known what's occurred. And as I say, there was absolutely no evidence that Ms. Burnham Ms. Earle had any idea what Burnham had done to the child. So Yes, maybe Ms. Earle was this 21-year-old young woman who was calling everyone that morning to say that her child was sick and vomiting green stuff. She's not hiding the ball there. She's telling people she's vomiting green stuff. She knows the child is sick. She's taking steps to take care of the child. She's getting ginger ale. She's making sure that the child is not left alone. She does leave the child with a 13-year-old, but at least the child is being monitored. There's absolutely no evidence that Ms. Earle had knew or had reason to believe that there was a plain and strong likelihood that death would result. And that really is the issue here. This evidence is absolutely insufficient. This evidence is certainly substantially less powerful than that in the Gallison case. Yeah.
I want to move on.
Yes, so do I.
I want to ask you this on that
Sure.
point. If you say this is getting to the manslaughter issue, I
Sure.
mean, whether an instruction should be given, and you say yes for the reasons partly you said, but also that it would be unfair to require her to give up her statute of limitations. But assume for the minute that we were to follow the U.S. Supreme Court,
Sure.
say it is fair. Didn't the judge in any event, as part of her instructions, specifically explain the difference between, the intent necessary for involuntary manslaughter and malice, the third prong of malice?
It is true that the judge did say that a finding of third prong malice requires more than mere recklessness and more than a mere high likelihood of substantial harm or injury to the child. It is true. But what the judge did not do is give the jury an option to convict on the lesser included offense of manslaughter. And I think Justice Brennan, in both the Beck v. Alabama and the Keeble case, explains that unless you actually submit...
But Beck didn't have a statute of limitations problem, did it?
No, I believe you're right. It was
Sparazzi, or I may be saying that wrong. The other case.
We should obligate a judge to give a jury an option where the jury believes it will result in a conviction, but in fact it will result in an acquittal?
Yes, I mean, the Commonwealth suggests that there's something deceptive about that, and that is the basis for the U.S. Supreme Court's holding in Spaziano.
But you try to distinguish Spaziano.
Isn't it a bit deceptive to a jury? I mean, the jury brings and says guilty. A reasonable person would think that guilty constitutes a conviction for which there's going to be a sentence.
But Massachusetts juries, unlike the Florida jury in Spaziano, never, and in all cases, as a matter of statute, Massachusetts juries are simply have the very focused role of applying the law as given to them by the court and perhaps as determined by the state legislature, and of applying the law to the facts that they find to render a verdict. They have no role in imposing sentence. They have no role in entering judgment.
We do require a general verdict. We don't permit them, as in a civil case, simply to do findings of fact. They have to say the word guilty. So that's a little bit different from a civil case where they arguably could make specific findings, and it may, depending on, say, comparative negligence, may result in no liability. But here a jury is asked to say guilty or not guilty. And is there any other instance in which we've invited a jury to say guilty where the consequence is an acquittal?
I'm not sure, but the legislature enacted a statute of limitations defense. There's absolutely no exception in the statute for this sort of situation. And I believe it's incumbent on this court to follow the legislative command here. In addition, we routinely withhold evidence from juries in this case. That's not we don't decide as part of our system of law that juries are to get all the evidence available to them.
Evidence.
In Fourth Amendment
this isn't
cases.
Evidence.
But
I wanted to ask you, in Spaziano, did the United States Supreme Court rest their decision on the fact that Florida juries decide the penalty?
That was certainly mentioned in the,
But
that was
that-
absolutely mentioned.
But was that a basis for their decision?
I think one could argue that it was part of the holding of the case retrospectively viewed, but that's not primarily what Justice Blackmun talked about in his
As I
opinion.
read it,
That's-
that they don't, that isn't. the
I
basis for
would
their
would
decision.
strongly commend this court in looking at this issue to look carefully at the New Jersey decision in the short case. I think it's brilliantly worded, and I also think that it's more consistent with the texture of decisions in this court than any of the other decisions, including Spaziano, are.
I'm sorry, it's overtime. Do you know which way the majority of jurisdictions go on this issue of instructing on a lesser-included offense, which is time-barred?
I would say that there's a real split, and I didn't come up with a majority-minority. What I can say is that there are definitely courts like New Jersey and Wisconsin that have written very forceful, intelligent, and strong opinions that suggest that that there are two independent rights here, and the statute of limitations needs to be enforced. There are other courts like Maryland v. Bauer, like the Maryland court and the New York court, which decide to the contrary, and then there's Vermont, which decides in a middle ground fashion that you must give the lesser included manslaughter instruction, but in addition you must inform the jurors about what the sentencing consequences are of their verdict. I would suggest that that's certainly possible, that this court could consider doing that, but I would suggest that that's probably not appropriate given the texture of this court's decision, because our juries, with the one exception of not guilty by reason of insanity instructions, our juries simply don't get informed on the sentencing consequences of their verdict. Once they hand in their verdict about the most appropriate greater or lesser included offense, their job is over, and the entering of judgment is simply a matter for the court.
Thank you, counsel.
Thank you, Your Honor.
Good morning. If it please the court, Gail McKenna, Assistant District Attorney for the Commonwealth. I'm going to start where counsel left off and explain what the difference is in statute of limitations. There's a fundamental difference between the three courts that have, and that's New Jersey, Wisconsin, and Vermont, that have found that it's appropriate to instruct the jury on a theory of not guilty. And the problem there is that in those jurisdictions, the statute of limitations is jurisdictional. Here in Massachusetts and in the federal court and in virtually every other jurisdiction across this country, the statute of limitations is an affirmative defense that a defendant can waive. And just as this defendant was given the ability to waive that, in all those jurisdictions, a defendant can waive that defense.
What authority is there that the defendant can waive the statute of limitations in a criminal case?
What's the authority? The Bougus case here in Massachusetts and the cases that are cited in the Bougus case, cases going back to the 1950s. And the particular case in Massachusetts in the 1950s relies on a Supreme Court case from the 1870s. But getting back to those three cases, which truly are exceptional because the statute of limitations is jurisdictional, it means that the charge itself never comes before the court. The defendant in those three jurisdictions cannot waive the statute of limitations. That means the defendant is in a far different position. In New Jersey, the legislature took care of it because statute of limitations, of course, are a matter of legislative grace. The legislature completely removed the statute of limitations as far as manslaughter was concerned.
After the short case, is that what you're saying?
Correct. In fact, while the short case was pending, they took care of it.
I'm sorry, I'm really misunderstanding your argument. You're saying
Sure.
in New Jersey, Wisconsin, and Vermont, at the time that these cases were decided, a defendant could not waive statute of limitations?
Right, because it was jurisdictional.
And how does that affect how they decided that the jury should be instructed on a manslaughter?
You know, it's one of the things that really springs to mind when you're reading the case is that there's something really intellectually dishonest about how the courts approach it. Because if you don't have jurisdiction over those charges at all, how do you ever charge a jury on theories of innocence? And yet the court goes ahead and does it. In Wisconsin, they do trick the jury, and they say it's fine to do that because there's no punishment involved. Vermont, agreeing with the Supreme Court, at least as far as that's concerned, uses extremely strong language, even stronger than the Supreme Court, in saying that it undermines the very integrity of the criminal justice system. And I would ask that the court look at that. What Vermont also does, though, is Vermont gives to the jury this the option of finding somebody not guilty based on manslaughter. Again, a
They're
charge.
basically instructed that if you find the person is guilty of manslaughter, you
Right.
essentially acquitted him.
Correct.
That's
Again,
the
a
instruction.
charge they have no jurisdiction over. And I think something that's quite problematic under fundamentals of what our burdens are here in the United States, which is that the Commonwealth has to prove guilt beyond a reasonable doubt. There's no burden on anyone to prove innocence. So where does the burden lie when an instruction like that is given? The burden's certainly not on the Commonwealth to dispel every possible hypothesis of innocence, no matter how far-fetched. It's not on the defendant to prove his innocence. So when a charge like that is given in Vermont, I'm really not sure how that works out as far as a matter of due process, as far as Webster, and as far as what the burdens are and what the established burden is
But
that
the
all
whole,
of
the
us
whole idea
accept.
whole idea of giving a lesser included offense, and why we say it's often required, is to provide the jury with a framework in which they can make a final judgment as to where the facts fit best. And if the framework is it's either way over here or way over there, that may force the jury to convict when in fact a middle framework would be more comfortable and more consistent with the facts. But that stark sort of separation can lead to an injustice. I mean, that's the whole reason we use lesser includeds, and they're really required when the evidence would support it. And the evidence clearly supports a lesser included here. You would agree.
I think that it's a close case, but the defendant
You
on
really think this is a close
manslaughter,
case?
that it would only be substantial bodily injury rather than the likelihood of death resulting. This child was only leaving that house in a coffin. I mean, I think the evidence was quite clear of that. This child was gravely, critically ill.
Well,
and
according
had been
to
for
the doctors who
hours.
did the autopsy, after they did the autopsy, they could conclude that.
Well, the
And
mother
they could see
watched.
what was going on inside of the baby's body.
We have the objective evidence of what the mother would have been observing over the many, many hours that this child suffered and died, including her intense pain. We have the mother also saying that as of the night before she'd stopped urinating, she was vomiting green fluid. She was in
But don't you
tremendous...
have the brother's testimony? I think that he changed her diaper that morning and it was wet.
Only that he changed his diaper. He wasn't able to say whether it was wet or dry. He changed her
I
diaper.
thought he said it was wet, but okay.
I mean, that's my memory of the testimony, Your Honor. That she, when at the point at 9 p.m., as soon as the defendant had gone upstairs and started drinking, that the little girl from upstairs came down and she was screaming like a banshee. The defendant's own sister, Deborah Earle, who called during the
So
day and heard...
the little girl goes to the defendant's apartment where someone has the baby, her boyfriend, and the baby
Michael
is
Burnham.
screaming.
Correct. Like
This
a
is an un-
banshee.
This is not so unusual. The child is sick. The child's got the flu. We know that.
The flu is not something that makes a child scream like a
A
banshee.
stomach ache, a bad stomach ache, anything like that, unhappiness with being held by someone they don't want to be held by when they're not feeling well. I mean, there are lots of reasons why a child might be screaming like a banshee. And she wasn't screaming later on.
Well, coincidentally, we also know that at that time Michael Burnham had stomped and twisted this child into the ground.
Before or afterwards? Do we know that?
We know that right before that, based on Burnham's conviction, but you know,
What was the evidence in this case?
the evidence in this case was circumstantial. That, in addition to the fact that this child hadn't been seen by anyone for a couple of days before that, was covered with bruises that were four days or less old, that at that operative time, and it was probably 20 hours before her death, 20 to 24 hours before her death, that she had sustained this horrific injury, that Michael Burnham was alone with him, with Rachel, which was something
Can I
that
ask you a
never
question?
happened.
When did the baby die?
The baby died around 2:45
In the
on
afternoon.
Thursday.
On
Mhm.
Thursday.
Right.
And so the baby, it was 9 o'clock the night before when the baby was screaming?
Yes. And that would be consistent with when she would have been stomped.
Do you
death.
think, is there evidence in your view that warrants a conclusion that this defendant witnessed Mr. Burnham stomping on her? On
Yes,
the
Your Honor.
And
The
what is that
circumstantial evidence being that the defendant had turned 21. She had plans from the day before to go upstairs to the apartment above and to celebrate her birthday.
Right.
She came upstairs. Colleen, the little girl, was sent down to get a glass. At that point, when she went down, immediately on the heels of the defendant coming upstairs.
child screaming like a banshee? And
Correct.
That's the evidence that's the evidence
No.
from which you infer?
No, there's more. The defendant is upstairs, and her conduct is not her normal conduct. She starts tossing down drinks, which is not what she normally does. It's her birthday. It's supposed to be celebratory, and she's not in a good mood at all. So based on those circumstances, and based on the timing of the injury, and the fact that the defendant also told Colleen that Rachel was in bed, which wasn't so, based on how the immediacy of what happened, it's an inference that the jury could draw based on the evidence. And remember, the inferences only have to be reasonable and probable, not inescapable.
I'm having some trouble with the reasonable part of that.
Well, based on the timeline, too, that the doctors set out for it, it's reasonable that it happened then, that she was there, and based on her conduct later, which was not befitting someone celebrating her 21st birthday, getting out from babysitting a baby, that she felt a lot of frustration.
Maybe she just had a fight with her boyfriend because he didn't want to stay and take care of the baby, and that's why she's in a bad mood.
Well, that's a different inference, Your Honor, but all the inferences we have to come up with are only those that are reasonable and probable. And it's reasonable and probable based on everything that happened that she knew. But as Judge Giles found in her new trial motion, and I think she's right, that the injuries alone were enough for this mother to know that this child, the child was covered with bruises. No one had seen her in 2 days. She wasn't going to the hospital.
What do you mean no one had seen her in 2 days?
Witnesses testified, the girl from upstairs, the mother upstairs, that they normally saw her every day. No one had seen her. Ray Gaffney hadn't seen her, who lived in the apartment. We had the lineup of witnesses, the people that normally saw her, and no one had seen her in the 2 days before. And she had the bruises of various ages all over her. She had a $50 bruise on her face. She had a cut on her lip. She was covered.
Covered, that's what the evidence, she was covered in bruises.
Your Honor, they're all listed in my brief.
And did any of these bruises have to do...
Page 44.
Did any of these bruises have to do with the assault that her boyfriend made on the child?
They were of various ages, so some may have been, but some were older bruises. There was more than one beating that this child sustained. There were fresh bruises, older bruises. This child herself was evidence of a crime. She was not going to go to the hospital. And we also have the older incidents where this child, she supposedly ingested Visine, a furniture polish, and she wasn't taken immediately to the hospital.
But you're saying, I take it, that the jury could have reasonably inferred from the fact that these people who normally saw this child on a daily basis and had not seen her on these 2 days, the jury could reasonably infer that that was the result of an act of concealment by the mother, by the defendant.
Based on the beatings that she had incurred, and then the stomping, which was what led to her, the peritonitis and so forth, it reasonably happened about 24 hours earlier, which fit with about the time that the defendant went upstairs for her party, and didn't end up being a party because the defendant didn't act how she normally would have, and Colleen comes downstairs and the baby's screaming. So are there other inferences?
20 to 24 hours earlier. Maybe I don't do the math very well anymore.
Well, it's
that would
not
mean
precise.
in the afternoon of the day, not... So you're saying long before 9 p.m. the baby was stomped. That's what you're saying? That's what the evidence was?
No, the evidence was 9. The times are estimates. And those were the doctor's best estimates.
So the estimate was within, was it anywhere
Within.
up to 20 to 24 hours or within 20 to 24 hours?
Furthest out was 24 hours.
Furthest out.
Yeah, in one, yeah, that's what the estimate was. So the evidence was more than sufficient in this case. But getting back to the statute of limitations, which I think is the court's real concern here, the defendant at all times, unlike the jurisdictions that the defendant mentions in his brief, Vermont, New Jersey, Wisconsin, had the option of waiving this defense. In those jurisdictions, there's no option at all. There's
But you will agree with me, the legislature has made a very specific decision that if you have committed manslaughter, but you are not prosecuted for a period of years so that the statute of limitations runs, you cannot be convicted of it. I mean, that's a policy judgment. They've made it very clear.
I have to disagree on one point, Your Honor. The legislature, you're also allowed in Massachusetts to waive that. It's completely in your hands what happens. And that's what differentiates it from those other jurisdictions where it's jurisdictional and not an affirmative defense.
Was waiver discussed with the defendant in this case?
There was a full colloquy, Your Honor, with the judge, a full colloquy. And I would also ask, and I think it's either Judge Cowan or Judge Botts that brought up the instruction that was given here, which fully appraised the jury of the very high standard by making the comparison to what that it had to be more than reckless and it had to be more than the manslaughter instruction. I mean, there was no way that this jury could have convicted this defendant unless they found that one of the three prongs of malice. And all three prongs of malice were before this jury. This wasn't simply a contest between the third prong of malice and manslaughter.
And is your view that the evidence is sufficient as to all three prongs or only as to the third prong?
As to all three prongs, Your Honor.
Is this a Woodward-type case because where the defendant really wanted to get an all or nothing?
I have to presume that, Your Honor, but I have to say that the defendant cites in his reply brief Woodward and some of the other cases, and I think it's important to look at those because the court made the distinction that the lesser included should be given in the cases where it's called for and you can get a conviction on that. And the two things go hand in hand. In every single case, it's where it's called for and there can be a conviction on that charge.
Otherwise, it's the option of a lesser included offense that drops out of the picture is essentially made available by the Commonwealth's failure to meet its burden of proof as to second-degree murder.
I'm sorry, Your Honor, say that again?
The option, in a sense, is still available.
Right, if we didn't meet our burden.
And it's available because the Commonwealth may not meet its burden of proof as to the elements of second-degree murder.
Correct. She would be acquitted if we failed to meet our burden of proof on first or second-degree murder.
Thank you, Ms. McKenna.
Thank you all for your kind attention. I ask that the conviction be affirmed.
Thank you. We're going to take a recess after this one.